The moot question in this case is, as my learned friends have already argued before your lordships, that there is no distinction between pre-2013 appointees and post-2013 appointees. All of them belong to one cadre. After regularization of service, they belong to junior SCS cadre. By virtue of that repeal rules, 2022 rules, now a discrimination has been caused. Discrimination is, my lord has seen that 2022 rules. Discrimination is, according to me, subject to your lordship's acceptance. My lord, from the day one, their service will be regularized. They will get 6 annual increments, notional increments. They will get the benefit of seniority. They will get the benefit of promotion. Everything has been spelled out in that 2022 repeal rules. But so far as these contractual teachers were appointed prior to 2013, although they belong to the same class and by facing due process of selection, they were recruited. My lord, for them, such benefit has not been extended. My lord, I am just placing the cadre rules of 1993 because after regularization of service, they will be included in one cadre, that is junior SCS cadre. My lord, may kindly see the education manual, page 585. The nomenclature of that rules is page 585. The nomenclature of that rules is the Odisha subordinate. My lord, 593. The Odisha subordinate education method of recruitment and conditions of service rules 1993. This is the statutory rules which will govern after their regularization. My lord, may kindly come to rule 3. Cadre of post in subordinate offices, rule 3.1. The service shall comprise of 2 grades, namely junior grade and senior grade. Then sub-rule 2, the junior grade of the service shall consist of the following categories of post, namely a headmaster/headmistress of government upper primary schools, B, assistant teachers of high schools. We are concerned with assistant teachers of high schools. They belong to junior grade of the service. My lord, now your lordship may kindly come how seniority will be maintained. That is rule 18. Page 600. Sorry, page rule 27, page 602. Determination of seniority. The seniority, my lord, got it. The seniority inter se of persons appointed to the junior grade of the service, both by way of direct recruitment and by promotion in a year, shall be determined in the order in which their names appeared in the list prepared by the committee in pursuance of rules 14 and 15 respectively, provided that the persons appointed by promotion in a particular year shall en bloc rank above those appointed by direct recruitment in that year. Then proviso is there, provided further that inter se seniority of the persons included in the service by way of merger of other equivalent cadre of taken over high schools shall be determined by taking into account the deemed date of appointment of the persons of taken over high schools vis-a-vis the date of appointment of the directly recruited trained graduate teachers under subclause 1 of clause A of rule 4. Then the deemed date of appointment that has been explained under the explanation. Then your lordship may kindly come to sub-rule 3. The seniority inter se of persons, this is important. Seniority inter se of persons appointed to the senior grade of the service shall be determined with reference to their position in the list prepared in pursuance of sub-rule 4 of rule 18. My lord, so my submission before your lordships is, by virtue of 2022 rules, the benefits which has been conferred on the initial appointees who were appointed after 2013 rules came into force. Since those benefits have not been extended to the post pre-2013 appointees, virtually they will be treated junior to a person who has been appointed earlier. And so far as promotional benefit
Junior?
is,
How do you make this submission? How
But-
are they going to be treated?
but your lordship may kindly see 2022 rules, repeal rules.
What is that?
Repeal rules, my lord may kindly,
So is this your submission? That they will be treated junior because of this?
yes.
My learned friend is covering that group 2011 to 2016. There are three groups, as I said to my loss. Persons appointed prior to 2011, appointed between 2011 to 2013. Under new rules, they
From
have,
the day one, they will be
they
regularized.
have taken one date, 4/4/2016,
Yes,
as the date of their counting of seniority, so far as the second group are concerned. So the person who is appointed in 2011 will be counted regular from 4/4/16, and a person appointed in 2013 also will be counted regular from 2016.
2016.
So in that process, the 11-year employee becomes junior to, or he is losing his seniority,
No, losing, who becomes junior to a person appointed?
losing seniority.
Huh?
Losing seniority.
Seniority, he does not lose seniority. He may be losing years,
Yeah, exactly.
not the
Exactly.
seniority. There
That's
is
Yes,
the
difference.
yes,
3-year
yes,
period,
yes.
the whole
Why are you
submission.
making with I got confused because of this submission.
Right, not right.
There's
That's-
difference between seniority and losing.
Losing, yes,
Absolutely.
Please.
yes. Well, then so far as promotional prospect is concerned, that is also being hindered, because the persons who are appointed subsequently, they will get promotion earlier.
See, if today a person is appointed
My lord,
against a post
yes,
having pay scale of 20,000,
my lord,
all right, and whatever. But the same post was there 10 years before. And for that, the pay was 3,000.
yes.
Can you take a plea that this person has been appointed recently, he has been from day one getting 20,000, and I have been receiving 3,000 from that date, and no care has been taken for us. We should have been given something more than the persons appointed today. And today a decision can be taken that those appointed long back in 2003, they shall also be given the same scale, 20,000. So will that be discriminatory?
My lord, what my lord has said, that is correct. But my submission before your lordships is, my lord, the benefit which has been extended by virtue of 2022 repeal rules, that has not been extended. And secondly, my lord, by virtue
See,
of-
if you want to add something
yes,
to what has already been
My lord,
submitted, it's all right.
my lord, I will cite some decisions. So far as discrimination is concerned, your lordship may kindly see. Because they belong to the same class. And ultimately after regularization of service, they will be included in one cadre. And all benefits will be, my lord, all benefits will flow from 1993 rules. My lord, may kindly see the decision of Sri Lalita first. My lord, may see paragraph 26 of that judgment.
Yes.
Service jurisprudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly. Only because one person has approached the court, that would not mean.
Why are you making this submission? Please don't waste court's time.
Then, my lord, so far as the virus is concerned, my lord, I have brought a decision, that is Independent Thought versus Union of India. My lord, may kindly see this. Where discrimination is caused Either that can be struck down or it can be read down. My lord, may kindly come to paragraphs 165.
Mr. Counsel, that question will arise after the court reaches a conclusion that there has been discrimination.
Yes, yes, yes.
All right. So
Yes,
if you are satisfied that discrimination has been caused, stop it. Stop your argument. We will consider.
yes.
All
And
right. Conclude your argument.
my third plank is, my lord, my third plank of submission before your lordships is, my lord, in some cases by the single bench, it has been held that those who were appointed prior to 2013 for the purpose of regulation of services, their services, my lord, they have to take recourse to 2013 rules. My lord, I have brought some judgments, single bench judgment, which has been upheld in the writ appeal and also in the Supreme Court.
We will follow that if that is required. to be
Yes,
followed.
yes. My lord, may kindly see this. Because their government stand was that since they were appointed prior to 2013, so 2013 contractual appointment rules will not be applicable. But this honorable court has held that 2013 rules will be applicable. They will get the benefit under the 2013 rules. And in fact, those judgments have been upheld by the division bench and also in the Supreme Court. Well, two judgments are there. One in the case of Sagarilal Murmu and one Akshay Kumar Mahanti. And the division bench orders are also there, where writ appeals have been dismissed. Writ appeal was- This is my argument. Let them give reply.
My lord, I may be, pardon me, lord, if your lordship would permit me. Only one thing I may add. My lord, your lordship may kindly have a glance to annexure 10 of my brief. Now, this rule 4. It's number. My lord, this is WPC number 36039 of 2023. Only one thing I will add, my lord, that is how it is discriminatory. The rule 4, if your lordship is looking at the rule, then I may place it.
Yes.
Let this special provision under the heading, the initial appointees appointed under the contractual rules, Miller at page 133, you will not support by.
Yes.
The initial appointees appointed under the contractual rules now in positions shall be deemed to have been appointed against the post on regular basis as on the date of commencement of these rules. Now, this is very important. Now, they basically what they intend to do, all those teachers who came to be appointed following the contractual rules of 13 and 14, so they would be regularized after completion of 6 years of service. But here under the 2022 repeal rule, they say initial appointee has been defined, you have already seen it. So they say that the appointments made under the 13 and 14 contractual rules. From the by virtue of this special provision, they confer the benefit of a regular recruit from the date of their initial appointment. Suppose I am giving an example. Following the 13 or 14 rule, even a teacher who came to be appointed in 21, that is prior 1 year prior or whatever it may be, he would be deemed to be regular from the date of their his appointment, initial appointment. Which, even if this 6-year formula doesn't apply, they say that anybody whosoever has been appointed following the 13 and 14 rules, they would be deemed to be by virtue of this fiction, legal fiction.
If,
They want to-
if Mr. Acharya,
My lord,
there is yet another aspect of the matter.
my lord,
So you want
my lord,
that the restriction which applies to you
my
should
lord.
apply to them also. Like
Right.
you had to complete 6 years. Therefore, that should be applied to them also. They should also complete 6 years for regularization.
Right.
This is your submission.
No, no, not exactly like
Why
that.
not?
Milord.
Why not? If that is your submission, then
That's correct.
had there been any provision in the repeal act or whatever rules,
For
then
us, for us.
then you would have been satisfied that all
That's
right,
correct.
it is the provision that they should also spend at least 6 years for
Right.
becoming regular.
Man.
Then they will have to be noticed, all of them.
Milord, this is by virtue of this rule, Milord, that number nobody knows. They want to cut down our Milord benefits. Suppose everybody would have been regularized in
No,
normal.
see, you are seeking equality. So this is how
Right.
also the equality can be achieved.
That's correct. Milord, equality basically how they have infringed, that is the various this point by virtue of the standard operating procedure, which your lordship were apprised of on the last occasion. Your lordship would find it at page 140, seven Milord.
Yes,
Page
anything.
149 Milord. Only
Yes.
one thing this description they have given, where they have made three categories here. One group, as Mr. Roth and my learned friend submitted, that the teachers who came to be this initial appointee, they say, came to be appointed, page 149 below.
Yes, yes.
But here there is 149. For those teachers, initial appointees joined in accordance with the Odisha Group B post contractual so and so rules 13, Group C post contractual rules amendment rules 13, along with this department resolution number so and so dated 27/10/24. 14. The contractual stroke initial appointee teachers shall be allowed fixation of their pay as on the date of 17/10/2022 calculated notionally from the date of their joining by virtue of granting increments on completion of each year of service under normal circumstances. Illustration A clarifies. That means, Milord, suppose a person who has joined after post 2013, between Milord 2022, this commencement of these rules, from the respective date of his appointment, irrespective of the fact whether they have completed 6 years or not, they would be regularized. Milord, suppose we belong to that category of teachers, those who have been appointed between 2003 to 2012, prior to the commencement of
All right.
years. So 13 and 14 rule also contractual rule, they also postulate the same provision, six years of service and regularization. Now, by virtue of the special provision which they made in the 2022 rule, Milord, by giving them seniority, pay, everything from the date of even after completion of 1 year of service or maybe less than that, a 2022 appointee would also be regularized from 2022.
Acharya, your submission is focused on the reliefs which
Right.
have been granted to the persons appointed 1 year or something before the repeal came into force.
Right.
More against them, less
Right.
against your favor.
More in
agreeing-
their favor. And
No, your submission, you are challenging the privileges which have been given to them
Right.
more than your.
More.
Your interest, that means interest.
All right. Yes.
Now, this is exactly what they have illustrated in this SOP.
We will see.
Regularization of LOC, SOP, Milord, at page 149. So, Milord, we are covered this, Milord, this group B, your lordship may kindly.
All right.
Date of rest, teachers shall be, Mr.
All right.
Roth was-
Let us have the view of the other side also. The petitioners have made their submissions. Now we had to required we can. Hear you in reply. Let us see.
May I please, Lord? Let's see their prayer first.
Which case?
That 9791 of 2023.
Nine seven nine one.
97.
Yes.
May I read, my lord? Issue rule Nisi calling upon the opposite party to show court to why the rule 4 of Odisha Group B, C and Group D post repeal and special provisions rule 2022 shall not be declared ultra virus.
Yes.
This is the challenge, the rule, the virus of this rule is challenged. The question arises for consideration before my lords, whether they are governed, whether the prayer for quashing, are they affected if this rule is repealed? Second, whether they are covered under 2000, they stand on the same footing with the 2013 recruitage as per 2013 rule. As per my lord's direction, I have prepared all the instructions issued from time to time regulating their appointment and the resolutions. It's good. Second. They- Interoperability.
Yes.
My lord, your lordship, first resolution of the 2003. That is at page 1 of my today's compilation. Lordship got it. This is the resolution dated 4/11/2003. This resolution was issued for appointment of contractual teachers. I will draw my lord's notice to page 2. Let's see the page 2,
Yes.
that is emoluments.
Yes.
Now, why I am showing these provisions, my lord, I want to establish these employees are different from the employees who are recruited in accordance with 2013 rules. That I want to demonstrate this, my lord.
No, there is no dispute about that.
My-
Neither 2013 nor 2022 deal with their initial.
Yes,
appointment.
that I want to, why I am demonstrating and what is their nature of appointment and what was their condition of service at the time of their appointment. Let's see that emoluments. The trained graduate teachers, arts and science and classical teachers shall be paid rupees 2,500 and 1,500 respectively per month as consolidated remuneration. Then, my lord, then turn to next resolution of 2005.
Yes. Page
My lord, it starts from page 5.
7. You are referring to page 7.
Yes, my lord. That is clause 4 and 5. The trained graduate teachers shall be paid rupees 2,500 and Urdu teachers, TM and PTs shall be paid rupees 1,500 per month as a consolidated remuneration. Other conditions, my lord, while making contract, then my lord, the contract will valid up to the end of February from the date of engagement and can be terminated if she violates the conditions of the contract or is found unsuitable later on by the authority without assigning any reason prior notice. While making contract engage, the engagement order must make it very clear that the engagement is valid up to the end of February of financial year, and renewal of contract engagement can be considered only if the continuance of the post is extended with concurrence of the finance department and subject to satisfactory performance to be evaluated by the appropriate authority. And that selection procedure that has been mentioned in these two resolutions, those who are appointed in accordance with 2003 and 2005, there is no provision for regularization of their service. For the first time, the government came with a resolution in the year 2008. I have annexed page 11, you'll also see that the resolution dated 8/12/2008.
Yes, page.
Well, page 11, well. My regularization with three conditions, you'll also see that 1, 2, 3. First condition, the contractual teachers so engaged will be regularized in their respective post only after completion of minimum 6 years of continuous and satisfactory engagement. That 2 is important. After regularization, they will be eligible for all service benefits as applicable and admissible to regular government employees of the state. On the basis of this resolution, those who are appointed in accordance with 2003 and 2005 resolution, their services were regularized. And with the terms and conditions, they will get the benefit from the date when they were regularized. And accordingly, when they were regularized, they have been extended that benefit from the date of their regularization. Then,
Yes.
my next resolution of 25/7/2011, because many appointments are made in between 2008 to 2011. The last appointment on contractual basis was made on 4. Page 30. Note down what date, my lord.
Yes.
Last appointment on contractual basis in accordance with 2003 and 2005 resolution was made on 4/4/2010. Why I am submitting that has some relevance, my lord. Then LRC 25/7/2011 resolution.
Yes.
That it starts from page 13. Those who were appointed till 2010 after 2008. This resolution regulates their regularization. LRC clause 3 of that resolution.
Yeah.
The government, after careful consideration, have been pleased to decide that regulation of the service of contract teachers in government high schools shall be considered only on fulfillment of the following terms and conditions. Eligibility for regularization. The contract teachers must have rendered at least 6 years of continuous and satisfactory service. Only those contract teachers who have been recruited in conformity with the prescribed recruitment with due adherence to the relevant provisions of ORB Act in Post and Services for Scheduled Caste in 1975. Then you'll also say clause 5. The clause 3, the eligibility, clause 5. Creation of post of regularization of contract teachers. After identification of the contract teachers eligible for regularization in accordance with the norms set out at para 4 above, contractual posts held by the appointees shall be abolished and equivalent number of equal regular posts shall be created so that overall sanction strength of teachers remain unchanged. So only after creation of the post they will be regularized. Then, my lord, you'll assume that then very important, my lord, 7.
Yes.
The date of appointment in regular establishment shall be reckoned as the first appointment to the service with regard to all service benefits.
Yeah.
My lord, then 8. Consequent to the observation of such teachers, they shall be governed in accordance with the relevant acts and rules and instructions as are issued by the government from time to time in this connection. So from the date of regularization, they are governed under that Odisha Service CCA rules, and the rules they are mentioning that education, the rules mention that education manual. So they, from the date when they are regularized, all the rules are, they are binding by those rules. In accordance with these instructions, their services were regularized. Then, my lord, I'll again bring to my lord's notice the next resolution of the school and mass education, that 27/10/2014. At page 17, my lord. This resolution was passed after 2013 rule. And there is a provision in this resolution, page 21, clause 6 of that resolution.
Yes.
The emoluments and service conditions shall be guided as per the provisions of GA Department Notification number 32010, General dated 12/11/2013, and number 1147, General dated 17/1/2014, read with notification number 4587, General dated 15/2/2014 for Group C D employee. These notifications relate to the contractual appointment rules of Group C, Group D, and Group B. For the first time, this resolution in 27/10/2014 governs in accordance with 2013-14 rules. So all the appointments made after this 27/10 in accordance with 27/10/2014, they were governed in accordance with 2013 rules. All the appointments made prior to 2014, the last appointment by, that is 4/4/2010,
Yes.
they were appointed on contractual basis in accordance with the resolution of 2003 and 5. They have been regularized in accordance with the resolution of 2008 and 2011.
Yes.
And then I'll bring my lord's notice that 2013 rule. But before that, I'll again bring to my lord's notice one resolution of that government matter that is at phase 30. That is regarding regularization of contractual employees.
Page 13,
30 my lord, 30.
30.
My lord. Government NG and PG General Administration Department issued a resolution regulating the regularization of contractual employees, Group C and Group D contractual employees who are appointed prior to 2013 rules. Let's me see clause 1. A gradation list of such contractors shall be prepared by the appointing authority on the basis of the date of appointment. In case the dates of appointment of two or more employees are the same, their interest position may be decided on the basis of the date of birth, taking the elder as senior. Then, my lord, regular appointment of the above categories of contractual employees shall be made on the date of completion of 6 years of service or from the date of publication of the resolution, whichever is later. This is regarding regulation of the date was given, that is, that date is 17 September 2013. Irrespective of the fact they have completed more than 6 years, as on 17/9/2013, they will be regulated with effect from 17/9/2013. This is regarding that contractual employees who are not appointed under contractual rules, my lord. This is regarding Group C and Group D. And another resolution was also issued by the GA Department by at page 34. That is regarding Group B post. That was issued on 15/2/2014 at page 34, my lord. LRC page 35. Same provision. Irrespective of their continuance. On completion of 6 years, they will be regularized, but the date is 15 to 2014 in respect of Group B. In respect of Group C and Group D, that was 17/9/2013. Then I'll bring my lord's notice to page 38, the contractual appointment rules to 2013.
Yes.
Your lordship, there is clause rule 4.
Where is that?
Rule page 40, my lord, 40, my lord.
Page 40. Just.
Rule starts from page 38. I am bringing my lord's notice page 40. Rule 4. For the purpose of these rules, all contractual appointments made prior to the commencement of these rules shall be classified into 2 categories, namely, Category 1, contractual appointment engagement made against contractual post created with the concurrence of the finance department without following the recruitment procedure, including the Odisha Reserves vacancy in post and services for Scheduled Caste, Scheduled Tribes Act, and the rules made thereunder and the rules regulating the recruitment for the regular post. Category 2, the contractual engagement made through service provider agent with the concurrence of the finance department. Why I am doing my lord's notice? What benefit has been provided in these rules for this existing contractual employees? That your lordship see rule 8. The contractual employees belonging to category 1 and the persons provided by the provided agent under category 2 who shall be less than 45 years of age and shall have completed at least 1 year of continuous service in case they apply for recruitment under sub-rule 1 of rule 5 for any group C and group D post shall be allowed relaxation in the upper age limit for entry into government service, provided they satisfy all other eligibility criteria for the post as laid down in the relevant recruitment rules. They shall be allowed 1% extra marks in the total marks of the examination for each completed year of continuous service, subject to a maximum 15%, which shall be added to the marks secured by them for deciding the merit position. This benefit was extended in respect of existing contractual employees. But so far as those who are appointed in accordance with these rules in Rule 5 of this rule, what benefit they have? The LRC Rule 6. Before that, LRC Rule 5. Recruitment to the post shall be made on the basis of the provision of the relevant recruitment rules or executive instruction as the case may be enforced. Notwithstanding anything contained in the relevant recruitment rules or executive instruction as the case may be enforced, all appointment made pursuant to sub-rule 1 shall from the date of commencement of these rules be on contract basis. Rule 6. Status of for the purpose of contractual appointments made under sub-rule 2 of Rule 5, all vacancies existing on the date of commencement of these rules as well as future vacancies shall be deemed to have been converted to contract from the date of commencement of these rules, provided that consequent upon regular appointment under sub-rule 1 of Rule 10, the contractual post shall get reconverted to regular sanction. What I mean to say, my lord, here, my lord, when is appointed under these rules with a condition on completion of 6 years, he is to be regularized. And the post is there. Post is not abolished.
No, it says for the purpose of contractual appointments made under sub-rule 2 of Rule 5.
Well, all vacancies means all existing vacancies of regular vacancies. On the date of commencement as a future shall be deemed to have been converted to contractual post from the date of commencement of these rules. Provided consequent upon regular appointment under sub-rule 1 of Rule 10, the contract shall get converted to regular. What Rule 10 says, your lordship, is Rule 10.
Oh, you
Sir.
misunderstand 5 and 6.
Well,
5 says recruitment to the post shall be made on the basis of provisions of relevant recruitment rules or executing the instructions as the case may be enforced.
well,
So it simply says recruitment under 2013.
yes, under 2013. That I want to say.
All right.
And there is a post, the regular post is converted to contractual. The appointment will be made on contractual basis. On completion of 6 years, again the post will be reconverted to regular post.
No, where is that 6 years?
Yes, I am going that Rule 9.
So Rule 6 has the only consequence of all the posts
Yes,
which are vacant. All right,
yes, ma'am.
are to be treated into
Contractual.
contractual.
Yes,
posts.
yes, ma'am.
So that is the consequence of
Yes,
Rule
rules. That is the Rule
6.
6. So
That is the Rule
post
6.
exists.
posts exist vacant.
Post exists vacant.
Vacant existing posts stood converted into
Contractual.
contractual posts.
My lord.
Yes,
And it is only converted to regular post on completion of 6 years.
that is.
Yes, mention 9, Rule 9. Nine one, tenure of contractual appointment. Persons appointed under sub-rule 2 of Rule 5 against the contract shall continue on contractual basis for a period of 6 years. The period of 6 years shall be counted from the date of their contractual appointment under Rule 5. Then you also may turn to Rule 9.
Yes.
Rule 10. On the date of satisfactory completion of 6 years of contractual service under sub-rule 1 of Rule 9, they shall be deemed to have been regularly appointed.
Yes.
A formal order of regular appointment shall be issued by the appointing authority. This is the basic difference. Those who are appointed prior to 2013 and those who are appointed in accordance with the contractual rules. In contractual rules, there is a condition before their appointment, at the time of their appointment, they will be regularized on completion of 6 years of service. And there is a post which will be converted to regular post on their completion of 6 years of service. But the petitioners who were up before my lords, when they were appointed, there was no condition precedent for regularization of their service. Only after, sorry.
There's another aspect. See, on the date when 2013 rules came into force, there was no contractual teacher whose service was not regularized. There were teachers who were appointed in 2010.
Well,
The last person,
last
was
person
appointed.
for 2010, my lord.
2010. So they were yet to be regularized.
Yes,
Otherwise, all others were already.
all others are
Under
regularized.
under the earlier previous scheme. All right, then.
Yeah, Lord, so
So this is the distinction.
this is the distinction. So I want to demonstrate that they are not covered under 2013 rule and they cannot take the benefit of 2013 rule.
No, they are not claiming.
Now that I am coming. What they are, I have seen their prayer and I have heard their submission, their entire submission to cover them under 2022 repeal rules. Though they have challenged the FIRIS, what is their prayer before my lords? They want to get the benefit which has been extended to others in accordance with 2022 repeal rules. In one hand, they are challenging the FIRIS. In other hand, they are making a prayer before my lords.
They are making a prayer. They are saying that if you apply that to them also,
Yes,
then there is no problem.
no, that I,
You don't apply, then there is a discrimination. This is
Yes,
what they are.
yes,
Right.
yes, madam. Those who are appointed at the last contractual appointment are made on 4/4/2010 only because by the repeal rules, seniority was conferred from the date of their contractual appointment by those who are appointed in 2013. Only to protect the interest, those who are appointed on last appointment was 4/4/2010. The SOP was issued and that last resolution was issued protecting their seniority. Protecting their seniority, in accordance with 2014 rule, first appointment was made in 2016. So those who are appointed in as 4/4/2016, their seniority was protected. Only to protect their seniority. The last protection is that.
No, your submission is that the persons appointed prior to 2013, not in accordance with 2013 rules, in their cases, there was not certainty
Yes,
that
yes,
their services shall be regularized.
yes, that is my entire
Whereas
service.
those who were seeking employment under 2013 rules, they were certain that their services shall be regularized.
Yes. And why they cannot get the benefit that why they cannot get the benefit, and I have drawn my lord's notice that resolutions exist which post they were appointed and when one can get the benefit. Your lordship may see rule 36 of the Odisha Service Code. Rule 36.
Yes, what is that?
Permanent post. Permanent post means a post carrying a definite rate of pay and sanctioned without limit of time.
Yes.
So the one is entitled to all the benefits from the date when he holds a permanent post. I've shown my lords, on creation of a regular post, they were regularized. From the date of regularization, as it evident from the resolutions, they will get all the service benefits. As the post was created after completion of 6 years, they are entitled to all the benefits attached to the post. When the post was not there, they cannot get the benefit which is attached to that post. As 2011 resolution says, on creation of the post, they will be regularized. So they are entitled to get the benefit from the post they are regularized, not prior to that.
Yes.
And another aspect, my lord, they have never questioned their regularization. When they regularized in 2011, 2008, they have never questioned.
Yes.
And after 14 years of regularization, they are before my lords to get the benefit, all the benefits from the date of their initial appointment.
Yes.
And your lordship, I'll bring another point, my lord, your lordship, that 2011 resolution, one aspect only. Yeah, lordship, I say page 15, that 2011 resolution. Clause 9, my lord, of that resolution. It's page 15, my lord, 15.
Yes.
the pensionary benefits admissible to the state government servants under the newly restructured defined contribution scheme as per the amended provisions for the Odisha Civil Service Pension Rules 1992 Finance Department Notification 17/9 shall be applicable to these teachers. Why I am showing these facts, my lord? As they were regular, they are appointed, admitted fact, they are appointed in 2007, 2008, and 2005, prior to 2005. But regularized after 2008, regularized after 2005. So, as they were regularized after 2005, they are brought to the fold of new pension scheme. And now they are the members of the new pension scheme, not under the old pension scheme. Now, in other words, they are claiming the benefit of old pension if their service will be reckoned from the date of their appointment. They will be brought to the fold of old pension scheme. And when they are regularized in accordance with one resolution, and that resolution is not under challenge, and they have not challenged, the modality has been formulated in that resolution, how their service is to be regularized. And after regulation in accordance with the resolution, they cannot divert their claim beyond the scope of that resolution. And I have shown my lord that since they are not covered under 2013 rule, they cannot take the advantage of the repeal 2022 repeal rules. This is my assumption. And I have prepared the short note.
Should my lords give us a day time, 1 day time to
At least.
come back before my lords with his reply to my learned friend's submission. 1 day time,
Because we also,
because
because your lordship also posed certain questions. My learned friend has given some answers. We want very composite answer to
Exactly.
that.
so there will be uniformity in our reply.
I've not heard Mr. AG appearing on behalf of the state. I have requested on behalf of the petitioners to discuss this matter on Thursday. For
That will do.
Coming Thursday. Another matter your lordship has fixed to Thursday.
It will not take much time.
My lord,
They have to answer.
my lord, my lord.
To reply to this petition. It was from behalf of the state.
Thursday 2 p.m. man.
2 p.m.
So
We taken a better.